Hey Texans, did you know you may be able to pass most, if not all, of your assets outside of probate without ever having to set up a living trust? So it's Texas Week here on the channel because my brand new book, Estate Planning in Texas, authored by me with contributions from my Texas licensed attorney and contributing author, that book drops in just 2 days on Amazon. And today I'm going to show you how to make sure your assets go straight to your loved ones without court, without headaches, and in some cases, without a trust. So most people think a living trust is the only way to avoid probate, but in Texas, the law gives you a lot of tools that can accomplish the same thing, sometimes faster, less legal expense, and simpler. So in Texas, many families do benefit from having a living trust, especially if they want to avoid the court-supervised probate process and name a trustee to manage the trust assets and oversee the distribution of the trust assets after they pass away. Or they want to make sure someone can manage money for their beneficiaries after they die for a period of years. Or they're married and they want to leave assets in a trust for their spouse's needs, but make sure when their surviving spouse dies, those trust assets revert back to the desired heirs. But not every Texan needs a living trust. For example, someone in their 70s or 60s or even their 50s who, let's say, for example, has two responsible adult children who get along and can manage money maturely, may be able to avoid probate in Texas without a trust. So in this video, I'll explain when a trust is appropriate and when Texas can use some simpler options to accomplish the same goals. So the goal is to make sure the things you have worked for go directly to your family, keep it in the family, avoid all the government intrusions, keep it in the family when you're gone without those survivors getting stuck in a court and attorney involved probate process, because that probate, many people perceive it as a big pain. Your survivors will hire lawyers will file court pleadings, a judge gets involved, a judge has to decide on the validity of your will, and then inventories of assets have to be filed at the courthouse, and then a judge signs court orders ordering that assets be dispersed to the appropriate heirs. Many people want to set up their estate to avoid all that government intrusion. So let's take a look at the different types of assets that most Texans owned and how each of them can pass directly to your loved ones outside of probate. First, let's look at the no-brainers. Most people are aware of this. First, let's talk about IRAs and life insurance. So in Texas, your beneficiary designation controls who gets the IRA, who gets the life insurance proceeds when you pass away. So for example, if your IRA says it goes to your spouse, you designated your spouse as your primary beneficiary, it passes straight to them, no probate involved. When you pass away, your spouse will get your death certificate and will go to the financial institution where your IRA is being held, and they'll move your IRA into an IRA for your spouse. Again, no courts, no lawyers, no judges involved. But just make sure you name both primary and contingent beneficiaries, and remember to update these if you get married, if you get divorced, if you have kids, or if designated beneficiaries die before you. One common mistake is leaving a minor as a beneficiary. That can create complications for your family. And if you're leaving these assets to minor children or to someone who might have trouble managing a large sum of money, or to a child with special needs, then a trust is usually necessary to protect those assets. A trust can control how the money is distributed over time and ensure it's used for their best interest. But like I said, if you have responsible, mature adult children as beneficiary, you can usually just name them outright and the funds will pass directly to them without needing a trust. This makes the process simpler, faster, and keeps the assets out of probate. Next is your brokerage accounts and setting up TOD or transfer on death designations on brokerage accounts. In Texas, you can use a transfer on death or TOD designation for stocks, ETFs, mutual funds, or other investment accounts. When you pass away, the assets go directly to the person that you named on that transfer on death designation. No probate, no court, no delay. But same nuance. If the beneficiary is a minor, maybe one of your children or all of your children, or maybe grandchildren of yours, or maybe your beneficiaries are someone who might struggle to manage a large lump sum inheritance or a child with special needs, you may want to name a trust as a beneficiary instead of the individual. A trust can control how the money is distributed, protect it from creditors, and ensure it's used appropriately over time. On the other hand, if your beneficiaries are responsible adult children, you can usually name them directly and the funds will pass straight to them without the need for a trust. Now let's talk about real estate, which is often where people think probate is unavoidable. So in Texas, you can use a transfer on death deed, or TODD, to pass your property directly to beneficiaries when you pass away. So this is how it works. You sign and record a transfer on death deed for your property. You keep full control of the property while you're alive, and the transfer happens automatically at your death, avoiding probate entirely. So some of the uses for transfer on death deeds include it avoids probate for your home or land. It keeps your property in your control while you're alive. It's simple and usually low cost compared to setting up a trust. And the beneficiary takes the property automatically at death without court involvement. But there are a few things to watch out for with transfer on death deeds. The deed must be recorded before your death. If it's not, the probate will still be required. And it doesn't protect those assets. Again, broken record here, if your beneficiary is a minor, someone who might mishandle money, or a child with special needs. In those cases, a trust may still be appropriate. And a transfer on death deed doesn't avoid the requirement to settle the deceased owner's debts. So if the estate owes money, creditors may claim against the real estate, even if a transfer on death deed exists. But for most Texans with a straightforward situation and an adult responsible beneficiary, a transfer on death deed is a powerful, simple way to skip probate for real estate. Next up, another common one, POD for bank accounts. So this involves your checking accounts, your savings accounts, your CD, certificates of deposit. These can also pass outside of probate with a payable on death or POD designation. Just name your beneficiary at your bank on the proper POD designation form, and when you pass away, the money goes directly to them. Again, no court, no waiting. Vehicles. Even vehicles can bypass probate in Texas. You can name a beneficiary on your car or truck title using the vehicle title and registration form. It's called VTR-121 is the beneficiary designation form. It's a small thing, but it ensures your car or truck goes straight to whoever you'd want it to without probate. Now, even if all those things that you have, your home, your IRA, your life insurance, your brokerage accounts, your vehicles, all those other things, your bank accounts, even if all those things avoid probate, you still want a will and a durable power of attorney. Think of your will as a backup plan for anything that slips through. Now, you don't want anything to slip through, because if you still own something in your name when you die and you don't have it set up to avoid probate through some type of beneficiary designation or POD or TOD or other designation, there's going to be a probate required to use your will to get that asset through probate. But with a will, you can name your executor who handles that probate if there is a probate. And then, of course, in your will, you can name who will inherit any kind of probate assets that you might leave behind. And then you also want to make sure you have that durable power of attorney, and that's where you name someone that you trust to handle your affairs if you can. So you have to have that. If you have your real estate and a transfer on death deed and you become incapable of managing or selling if it needs to be sold, or incapable of signing your name at some point during the rest of your lifetime, and some transaction is necessary without that durable power of attorney, then people are going to go hire lawyers, go through a court proceeding, have you declared incompetent, and have a legal guardian appointed for you. All that can be avoided by having that durable power of attorney, which allows your agent to handle things if you can't, even including things like estate matters, trust matters, and tax matters. So having these things in place should give you some peace of mind and keep your plan somewhat airtight. And on top of all that, if you want a step-by-step guide for all this, plus the exact forms you need, my new book, Estate Planning in Texas, is coming out in just 2 days. And when you get the book, you'll also get a free access code where you can download the Texas statutory durable power of attorney that you can use. You can download will forms that are Texas specific. You can download the Texas statutory medical power of attorney and the directive to physicians and family, or what's also known as a living will, and along with some instructions so you can fill them out correctly. Okay, now a quick note. Doing all of this stuff yourself, setting up all of your beneficiary designations, your transfer on death designations, your payable on death designations, transfer on death deeds, all the vehicle title and registration forms, all that, can work well for many Texans with straightforward situations. But doing all of this estate planning kind of yourself is not for everyone. If you do have some complex family dynamics or minor children or a child with special needs, or you have significant assets or unique assets, or you have specific estate planning goals like creditor protection, tax strategies, or keeping assets in the family for multiple generations, then you're going to need to hire an attorney. A good attorney can help you structure your plan correctly, avoid mistakes, and ensure your objectives are fully met. So if you're watching during this Texas week on my channel, hit the link below to pre-order the ebook, Estate Planning in Texas. If you're watching after the launch, then both the ebook and the paperback book are now available. And if you want more Texas-specific estate planning tips, drop the word Texas, maybe in all caps, in the comments. I'd love to know so I can keep making these videos for you. Thanks for watching, and I'll see you tomorrow for another Texas Week episode.